A court file can survive 3 judges, 7 companies, and years of argument. One short section of an act can still close it. That is the constitutional lesson inside Smith v. Fonterra. New Zealand courts develop common law when legislation leaves a gap. Parliament can later fill that gap and remove the court's path. The story began with Mike Smith. He is an elder of Ngapuhi and Ngāti Kahu. In 2019, he sued 7 large New Zealand companies. They included Fonterra, Genesis Energy, New Zealand Steel, and Z Energy. Smith said their emissions contributed to damage affecting his Wenua and Moana. His claim used tort law. Tort law handles civil wrongs between people or organizations. It asks whether one party caused legally recognized harm to another. A successful claimant may receive damages or an order stopping harmful conduct. Smith relied on public nuisance and negligence. He also proposed a new duty involving damage to the climate system. The companies asked the courts to strike out his claim. A strikeout happens before a full trial. It removes a case that cannot succeed even if its pleaded facts are proved. The High Court removed 2 parts but allowed the proposed new duty. The Court of Appeal later removed all 3 parts. Then the Supreme Court restored the complete claim in 2024. That decision is often misunderstood. The Supreme Court did not find the companies liable. It did not order them to cut emissions. It decided the claim was not clearly hopeless before hearing evidence. That is a doorway, not a victory. A full trial would test causation, duties, defenses, evidence, and possible remedies. Climate harm makes every one of those questions difficult. Greenhouse gases mix in one atmosphere. One company's emissions join countless sources across many countries and decades. Traditional tort cases often have a shorter line between action and injury. A factory pollutes a neighboring stream. A careless driver damages another car. Climate change stretches that line across the planet. The companies argued that elected lawmakers should manage such a vast problem. Smith argued that scale should not make harmful conduct immune from ordinary law. The Supreme Court allowed that argument to be tested. It also noted an important absence. Parliament had created climate targets and the emissions trading system. Yet Parliament had not clearly displaced tort law in the climate field. That sentence pointed directly toward the next chapter. In 2026, the government introduced a bill to create that statutory bar. Parliament passed its 3rd reading in August. Section 271 removes tort liability for emissions-related climate effects. Its reach is unusually direct. It covers activities and emissions from before the law began. It covers existing cases not finally decided. The transitional schedule names Smith v. Fonterra itself. Affected people also receive no compensation because of the change. Parliament did not tell the Supreme Court that its judgment was wrong. It changed the law that the future trial would need to apply. That difference reveals how New Zealand's constitution works. There is no single supreme written constitution above ordinary acts of Parliament. New Zealand distributes power across Parliament, the executive, and the courts. Parliament makes statute law. The executive administers it. Courts interpret it and develop common law where statutes leave space. Those roles overlap, but they are not equal in lawmaking power. Parliament remains the supreme lawmaker. New Zealand also has only one parliamentary chamber. There is no elected Senate reviewing bills after the House passes them. The Governor-General gives royal assent after the parliamentary stages finish. Courts can examine legislation and interpret its meaning. They can declare inconsistency with protected rights in some cases. They generally cannot cancel an act because judges consider its policy unwise. The strongest control is usually political. Voters can judge the lawmakers who passed it. A later parliament can amend or repeal it. That arrangement gives elected representatives great power. It also places great weight on process, scrutiny, and constitutional restraint. Supporters of the climate amendment emphasized one national regulatory system. They feared court orders could create duties beside the emissions trading system. Different judges might shape policy company by company. Businesses would face obligations not designed across the whole economy. Opponents focused on access to justice and the timing. The planned trial had not examined Smith's evidence. The common law had not finished answering the question. Parliament stepped in before that answer could emerge. Both arguments concern democratic legitimacy. One trusts national policy choices made by elected representatives. The other protects a citizen's chance to test harm in an independent court. The disagreement cannot be solved by saying courts are undemocratic. Courts perform a constitutional job given to them by law. It also cannot be solved by treating every court path as untouchable. Parliament has authority to change common law. The real tension lies in when that authority should be used. Should lawmakers wait for a trial to reveal the evidence, or should they prevent a parallel system before it develops? Smith versus Fonterra makes that abstract question visible. A man asked the courts to recognize a duty. The highest court allowed him to ask fully. Parliament then changed the possible answer. Remember that sequence whenever a headline describes a court case as overturned. The judgment may still stand perfectly intact. The ground beneath the next hearing may simply have moved. Subscribe for more calm explanations of New Zealand's hidden constitutional machinery. This machinery matters most when one branch closes a door another branch opened.